entering into, then it sends a signal of that party intending that they will have a binding agreement between them. What is commercial setting? You can use ESO petroleum versus excess and custom to support your views on that. In terms of capacity to contract, which I said was one of the areas examined last year, you know that typically we talk about infants, and in the literature, infant is used synonymously as minors in the literature. Then you also talk about insane persons and persons who are intoxicated and persons who are drunk. Okay, not necessarily drunkards. A person who is drunk. A person who is drunk is not necessarily a drunkard. Okay, but the most controversial of all these categories of persons which are typically discussed when you're talking about intention to create legal, when you're talking about capacity to contract, is infants. Okay, infants. You know generally that an agreement between an infant and an adult will not bind the infant. Okay, particularly when you're talking about trading contract, the idea is that the infant should not be placed in a situation in which he risks his capital. Okay, his capital. So the law will not enforce the deal in favor of the adult party if he's entering into a contract with an infant, as a general principle. So the question often is, who is an infant? Okay, who is an infant? At common law, the age of majority is below 21. Minority is below 21. So if you are above 21, that will be the age of majority. You know that through the statutes of general application and also common law of general application, because the principle we are talking about here is not statute, although it has origins in statute in England. But so we inherited through common law of general application with that very important date of 24th July 1874, I believe, when certain legislation in England ceased to apply to us here, then Gold Coast. So 21 is held generally to be the age of majority. But increasingly, we have legislation. We have a lot of legislation which give people just who are 18 the capacity to do a lot of things which are contractual. Okay, and we have very recent legislation on what we're discussing as well. So the most recent one of them is the Lands Act. The Lands Act, look at section 281, the Lands Act 2020, which actually defines an infant as a person below 18. Then before then, the Companies Act 2019, which also defines an infant as a person below 18. Then before then, the Interpretation Act 2009, also defines an infant as a person below 18. So the question remains as to whether the age of minority for contractual purposes is really what used to be the English position of 21. The interesting thing is that the English have gone ahead to pass legislation to reduce the age to below 18. So bear these at the back of your mind. I can see that you have a lot of questions in the chat. Do we have Doc? Dr. Osudapa?
Mr. Amuzu, I'm here. I'm here.
Hello, Doc.
Yes, I'm here. Yeah,
I'm
here.
If we don't have Doc, I think we'll just have to keep going until.
I'm here. Can you hear me?
Okay.
Yes.
So, yeah. So, yes, I think that my students are very eager to engage. They want to ask questions. So we've been looking for you for some time.
Oh, right.
Okay. Yes. So
you know,
I see a number of hands up.
I've come to the village for
my preference will be, let me end this slide and then we can take the questions. Then I go to the next slide because I have 4 slides for us to go through.
Okay, all right, that's fine.
So if that is fine, just bear with me. I will finish this slide soon and then I can take questions.
Yes.
And then we go to the next slide.
Yeah, then that's fine.
Okay, good. All right, good. Now, so, I rendered the general principle regarding infancy and, an attempt to contract with an infant. Of course, there are exceptions, 4 main ones noted, which you should recall and keep in your arsenal for the purposes of the exams, okay? So a contract for necessaries will bind the infant. A contract which is referred to as beneficial contract of service will bind the infant. Beneficial contracts in general will bind the infant. And where the infant also acquires in a subject matter, acquires an interest in a subject matter of a permanent character, that will also bind the infant. Regarding necessaries, you can't go wrong with Nash versus Inman with this very old English case in terms of what necessaries are. Recall that necessaries, we're talking about the basic necessities of life. But for a basic necessity of life to amount to a necessary, it must be delivered at the actual requirement of the infant. Okay, so the infant must need it at that point in time, and it must be delivered at the time he needs it. Then the second consideration, 2 key considerations. The first is that it must be delivered at its actual requirement. The second is that the items must fit his station in life. They must fit his station in life in order to be considered as necessaries, okay? And you can't go wrong with Nash and Inman, Chappell versus Cooper, and the understanding of necessaries in the Sale of Goods Act. Of course, once we are talking about Sale of Goods Act, this is restricted to goods and not, everything, okay? Then beneficial contracts. Of course, where a contract is construed as a whole to be beneficial to the infant, it will bind the infant, quite apart from beneficial contract of service. Okay. Rely on Chaplin versus Leslie Fruin publishers, where this young man commissioned a book to be written, in his name. On the title, I couldn't smoke the grass on my father's lawn, but then retreated along the way because he felt he wasn't giving a true account of himself in the book. Okay, but the court concluded, well, as an infant, you wanted to be an author in life, so a book written in your name very early will be good for you, and therefore you must pay at least the price for the work which was done. So in this case, he was bound to an extent as far as this contract is concerned. Beneficial contracts of service, you're talking about situations which are more or less like apprenticeship, okay, where an infant is placed in the care of a knowledgeable person in society, somebody who may be an artist, a boxer, a musician, you know, mainly in the arts. You put them in the care of other people for them to receive training. Under what circumstances will those beneficial contracts of service bind the infants? Of course, the terms must not be harsh and onerous. Okay, so I mean, one of my favorite cases here is the Francisco versus Barnum. The Francisco versus Barnum. The other cases you should also just remind yourself. Then the last category, which is referred to as avoidable contract, but you're talking about contracts in which the infant acquires an interest in a subject matter of a permanent character. Remember, we are not talking about a permanent interest. We are talking about acquiring an interest in a subject matter of a permanent character. Okay. So here you're talking about leases, tenancies, which is tenancy basically is a short lease kind of, shares. So calls on shares will bind the infants. So Sternberg versus Scaler. Now, you know, it is possible that when you're talking about a trading contract, a contract which doesn't fall under any of the exceptions that I have mentioned, an infant may perform his side of the bargain, and the adult party may not have performed and will be setting up the infancy as a defense, you know, to the extent of saying that, well, this is a contract which cannot be validly enforced, you know, because you have an infant in this situation. The answer to that is that the principles are developed to protect the infant. So you cannot have an adult party turning around to use that to defeat, you know, the interests of the infant. And that's the position which was taken by Justice A.N.E. Emisa in Latte versus Panama. So keep that too at the back of your mind. Recall that the rules, as we have stated it on the position, you know, regarding infancy, may work hardship in many situations. Okay, there may be situations in which the adult party genuinely would have thought that he's dealing with an adult party and not an infant. But the rules are such that unless we are talking about those exceptional circumstances, the adult party may not be able to recover the price for whatever he gave out. One small window of opportunity is, you know, recovery through the equitable doctrine of restitution. Okay, but the principle here is also very much circumscribed, very much tight. So the adult party must locate whatever has been taken from him in the nature and in the nature in which the item was taken. If the item has been transformed into something else, he may not be able to recover it. It is the case even if the infant perpetrated fraud on the adult party to convince the adult party to enter into the deal with him. Leslie versus Shield. Now, the difficulty with this equitable restitution principle also is, when we are talking about money, for instance, in the days in which physical cash was what was predominant, it's easy. You can walk into the infant room, the money you gave him, you would have seen it there, or it is possible to see it there, and you take it, from him. But now you can have electronic money, electronic transfer all over. So if he has some money in his account, you transfer electronically. How are we going to be able to identify that the ones you sent him as the ones in the account to recover it? So those are, some challenges which the principle poses. The last of the topic on this slide is privity. So that in order to take a right or a benefit or be obligated under a contract, you must be privy to that contract, which means you must be party to it, you must have furnished consideration, and so forth. Okay. And the principle at law has been that if you are not privy to it, you cannot take a benefit or you cannot be obligated. Tweedle versus Atkinson, Price versus Easton. Now, obviously, this rule, this privity rule at common law, works a lot of hardship, particularly the part of the rule which says that if you are not privy, you cannot take a benefit. Because the whole idea of the parties may be to confer a benefit on a third party who hasn't contributed anything to any of them. So if that view will be defeated, then it's harsh. Okay, it's harsh. And because of the hardship, our Contract Act 25, 1960 has made some inroads, modifications to the common law rules. Okay, so look at Section 5, which recognizes third-party rights once the parties to the contract purport, which means intend to confer a benefit on the third party. Okay, they must intend to confer a benefit on the third party. What it means also is that if the third party is only an incidental beneficiary, he will not be covered. He will not be covered. So, in simple terms, Section 5.1 is an